Hi, everybody. This is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and welcome to Raw Law. This is the show where we answer your questions, and we're live in my office. So, welcome, everybody. And I see we have a bunch of questions. I apologize. I was a little late. I was just finishing up actually a call with someone else who had some questions. So, I was trying to do a consultation, and it ran a little late. But let's see. Let's get into it and see what people are asking so we could answer some of your questions. I see here a question from Callie F. Cool, and he or she says, "Hi, Arkady, how valuable are neurosurgeon notes?" So, yeah, I mean, it's not really, you mean valuable in terms of like useful? Yeah, I mean, everything is useful. You definitely want, when you handle a case as an attorney, you do want to review all the medical records. And you can have summaries of the medical records. Now they have a lot of AI summaries. There's a lot of companies, what they'll do is you just upload the medical records into the program, and then the AI will summarize it for you, but they'll have links back to the source document. So, for example, if I'm handling like a complex medical malpractice case with like some kind of brain surgery, neurosurgery, I can upload 1,000 pages, right? And it'll give me like a medical timeline, dates of treatment, and it's very accurate. And there are private companies that do it. I mean, some of them are called, I know there's one called Even Up, there's one called Supio, there's one called Eve. I think those are the three big ones that I know about. And I've played with them a little, I've tested them out. They're all very good, and they actually will write settlement letters for you. But, as an attorney, you do want to read the original notes, like the original progress notes from like the neurosurgeon. So it is helpful. It is valuable. Yeah. And then Virgo asks, "Hi, it's been 3 weeks and my lawyer still hasn't converted the video footage from my trip and fall. The only time I get updates is when I call and only talk to the assistant. I'm very discouraged. My physical therapist said I likely won't walk again. Do lawyers not prioritize contingency fee cases? It doesn't seem like he's doing anything. I've done all the work." Yeah, I mean, I can't really, it's not, you can't really like, categorize like that, like all lawyers, right? Like I do, it just depends. I think from what I remember, I think I was trying to help you, right? You texted me privately and I was recommending a lawyer for you. I don't know what happened with the lawyer I recommended. I think I recommended one or two. If you want, just email me back. I think the issue, if you still have that same lawyer you had before, from what I remember, I think the issue may be that that lawyer is just not a trial lawyer, and that lawyer is not a specialist in personal injury, right? Which is like civil justice, which is a subspecialty. I think that lawyer was like more of a jack of all trades. So maybe they have like a real estate closing and then a divorce and then something else. You know what I'm saying? And they're just not able to handle a case like that in the right way. I mean, sure, they could handle a PI case and get some money. Like, anybody could handle a PI case, get forms and just send out a complaint and then get on the phone and get like 20,000 offer. But if you want somebody to really litigate it the proper way, then you need a trial attorney. So yeah, I could try to, help you again, try to find someone for you. But I think that was the issue from what I remember. And in terms of like video footage, I mean, the lawyer doesn't even have to do that. If they send you a link or they send you the video, you just click it and it plays. I mean, converting it, you don't have to convert it. They have to give it to you so you can watch it. I know there are apps like VLC Media Player, and those apps play almost any format of video. So that should only take like, a minute or two. Okay, Jarell says, "Hey, Arkady, my question is, a lady ran the stop sign and ran into me back in July of 2022. I had a spinal stimulator put in, and they also did a radio frequency ablation, an RFA. They have 6 million in coverage." Okay, so that sounds like a good case. Yeah, I mean, she ran the stop sign. She's at fault, hit you in the rear. It happened a while ago, right? Almost more than 3 years ago. So what I would do is maybe file a motion for summary judgments. You get a judgment as a matter of law. That way, the only question is, what is this all worth? And if you have a spinal stimulator, that's pretty serious. That could be worth like 500,000, maybe even 1 million. And then you have this radio frequency ablation, which is also a procedure. It has value. It's not, I'd have to know what the spinal stimulator was for, because the spinal stimulator is almost like they do it as a pain relief, right? But what's the underlying diagnosis? Is it a herniated disc? Did you have surgery for the herniation? And then the radio frequency ablation as well, right? That's a procedure where they burn the nerves so you don't have pain from the herniation, but we'd have to know what the diagnosis is, like where the herniation is. Are there multiple herniations? What else was done? But yeah, I mean, it sounds like it could be really big, and 6 million is plenty of coverage. So you can do well. You can even get into the 7 figures on something like that. And then DND says, hi, Arkady, fell through a floor at a hotel, dislocated my shoulder, and had surgery. 3 anchors put in. They offered $275,000 before filing a lawsuit, but we filed anyway. There's a $2 million policy, and it's the Hartford. We sent discovery, and they asked for a 30-day extension, which ends October 8th. On a call recently, the defense says they are looking into an engineer. Should I worry about that? Also, they haven't asked for any discovery from us. Is that a good sign? Yeah. So, I mean, I think what people confuse, right, is that you don't have to worry about these dates, asking for 30 days. It ends October 8th. What you have to look at is more like the big picture. This case is just getting started, right? They just filed the lawsuit. They asked for the extension to October 8th just to file an answer. The answer is just going to say they deny everything, right? That's what an answer is. They're just an appearance. They're appearing in the case. You're going to have to do depositions. You're probably going to have to put the case on the trial calendar. And then they're going to give you, big money like a mediation. So all these dates now, they don't really matter. I mean, it's just getting started. The whole case is in its infancy, right? You have to look at the big picture. You have to go back and look at the kind of, you're looking at the tree, right? The tree, and you're looking at a leaf on a tree, but you don't look at just that one tree and the one leaf. Go back, right? Go up 30,000 feet and look at the whole forest. In terms of the life cycle, this is just getting started. They just filed the lawsuit. There's not even an answer. There's not even anybody to talk to, right? You have the Hartford, which is good. The Hartford is a good insurance company. So make sure you have a good trial lawyer that has gone to court and gotten whatever you want to get. If you want to get, let's say, 950, $1 million, make sure your lawyer has a track record and they've actually done that, and then let your lawyer run with it. Or if you don't have that lawyer, then get that trial lawyer. That's what I would say. But yeah, it sounds like a good case. I wouldn't worry about an engineer. What's an engineer going to say? I mean, a floor should not collapse. You shouldn't fall through a floor, right? You're standing on a floor. I mean, I wouldn't worry about that. You have 3 anchors. Yeah, I mean, I've settled anchor cases for $850, $950. So $275 is a good start if they're doing that before you even filed a lawsuit, pre-suit. That's a really good sign. That means that they're taking the case seriously, right? Because they could offer you 20 grand pre-suit, but they're offering you something substantial. So that means, yeah, if you litigate the case aggressively and your lawyer has a track record of multi-million-dollar results, then potentially the case could be worth into the 7 figures or substantial, right? 850, something like that. And so I think it's a good case, but you just have to understand, nothing's going to happen October 8th. It's you have to look at the life cycle. It might I don't know where you are, but it might take a year, 2 years, and then you'll get. So it's you have to let it kind of build up. It's almost you plant a flower and, you plant the seed, you want the flower to grow, you want a beautiful rose, but it doesn't come right away, right? People, that's the thing with people, clients. I know they always want everything right away, but it just doesn't work that way. You have to you have to water it. You have to put the, whatever, the vitamins, the miracle grow. It has to be sunny, and then it'll start growing, and then you'll start see it sprouting, and then finally you get the rose, and that's when, it's ready. So you just have to let it go. But that's a good case. I don't see any issues with that. And then Darren says, I've seen the independent medical examiner 2 months ago, still did not receive the medical report back yet with multiple injuries. This is in New York. Yeah, I mean, that's standard. They don't really give the medical report right away. They're very slow with that. And, and again, it doesn't really matter because okay, say you get the medical report. It's just going to say that your injuries are not caused by the crash. Your injuries are from living your life. They're degenerative, stuff like that. It's just they have the same report. They just take your name out and they take somebody else's name out. They put your name in. It's the same report. Why do you need to see it? Your lawyer will get it before the trial to cross-examine the defendant doctor if the case goes to trial. But remember, 97% of cases don't go to trial. So you don't really, you're going to get it, but I wouldn't worry about it. It's not if you got it today, nothing's going to change. It's not important, basically. I had a case against the city of New York where They had the report from like 2023 and they wouldn't give it to us. We had to file a motion. And then the judge said, okay, finally give it to them. And they finally gave it to us, I think like 6 months ago. And it was like 2 years we were waiting on it. Like, and they don't punish them because they, the city says like, oh, we're short staffed. We're the city, we're so poor. We're so, short staffed, whatever excuses. And the judges just like let them get away with it. So it took 2 years to get an IME. So if you're waiting just a few months, I wouldn't really worry about it. It's not a big deal. Okay, Jeannie says, do cases usually settle after an IME appointment? I have mine this upcoming December. Thanks. I mean, they could. Not really. I mean, there's not really. See, an IME, you got to understand what an IME is. First of all, it's not an IME. It's just called that. It's not independent. It's really the defense gets an expert that's going to support the defense position to say that you're not hurt, or that if you are hurt, it's from living your life, right? It's the painless, normal aging process. It's not from the crash or the fall. It's not traumatic, right? That's what they're going to say. So essentially, that's what it is, right? It's a defense medical exam but they have the right to do it, because if they didn't, right, think about what would happen. Like, you have your doctor, right? So you had surgery. So your doctor comes in and says, I'm Dr. Smith. This is my, patient. Like, Jeannie is my patient. She came to me on her own. She was in pain. I helped her and she needed surgery. That's my medical opinion. And he testifies, right? And he does a great job and he's a nice doctor and he has like 30 years of experience. But then wait a minute. Don't the defendants, the people you're suing, if they want to call a doctor, you can't tell them legally you cannot call a doctor. So now it's this beautiful doctor with 30 years experience, you're treating surgeon versus nobody. So who's going to win? You're going to win, right? So to level the playing field, the law says that they have the right to this independent medical exam. But if it was truly independent, if they were really going out and doing like, both sides, the plaintiff and the defendant would go out and say, well, who's really independent? Who's the best doctor? Let's open up like US News and World Report. Who's the best doctor in this city? Let's go to that doctor and see what they have to say. Have the doctor examine the patient. We'll give them all the medical records. But that's not how it works. The way that they've kind of ruined it is that they get these doctors that aren't even doctors. They're not practicing medicine most of the time. They used to be, maybe in the 80s or something. They just sit around and they write these reports, and all the reports say is that you're not hurt, and if you are hurt, it's not because of this. And it's like a cookie cutter, and they just take your name out and take the name out of whoever was there yesterday and put your name in. They see, like, literally in an hour they could see like 10 people. In a day they could see hundreds of people. And it's just like a factory. It's like a litigation factory. They're basically, I called them one time jukebox witnesses, because it's like a jukebox, right? When you go to one of those diners where they have the jukebox, I don't know if people, it's a little bit of an older thing. Maybe the young people watching, they won't know that. But a jukebox is like, you go up to the jukebox, you see what songs are playing, you put money in. That's the first step, right? You got to put money in. Then you pick your song, and then guess what? The jukebox plays the song. So that's the same thing, right? You go to the doctor, you give the doctor money, you tell him what you want him to say, and then because of that, the doctor says what you told him to say. It's like a jukebox. So I wouldn't really worry about those, IME doctors. In fact, if you have a good trial lawyer, they're going to destroy the IME doctor. So, and, but a case could settle after the IME, but there's no like correlation between the IME and settlement. It's just the only reason it's really important is because if you're already having the IME, it kind of means that you're, towards the latter stages. Like I was giving the example of the 30,000 feet, we step back and we look at everything like the forest. So you're already done, right? If you're doing the IME, you probably have had depositions. You've probably, done a lot. So you're already like maybe 75% done in terms of the timeline. So in that sense, it could settle, because if you're on the trial calendar, you do that IME, yeah, it could definitely settle. You could do a mediation. You could take the case to trial, or settle it when you're picking a jury, things like that. And then Money Dog says, what would you do if the defendant is bringing up old medical history that is not related to your TBI injury? Well, I mean, if it's not related, just make a motion in limine to exclude it, right? It would be irrelevant under the rules of evidence, because if it doesn't tend to make a fact more probable or less probable, then it's irrelevant. If it's completely, old medical history. I mean, like they would have to have a medical opinion to say, hey, this old medical history is what's causing the brain injury, not the trauma. If they have that opinion, well, then you have to cross-examine them on it or talk to your doctors about it, like your experts, your neuroradiologist, your neurologist, and then have your experts explain why that's phony baloney, that's nonsense, and then just, basically destroy their opinion. But if it's irrelevant, that's different, because it's irrelevant, and it's just like, it shouldn't come up at all. Okay. And then Barney says, can't wait till I get the chance to do a one-on-one call. You're very knowledgeable. Thanks. Again, I know you're busy. Oh, yeah. Just text me. I'm happy to do them. I did like 1 or 2 today. I'm going to try to do 1 or 2 more tomorrow. I've been a little bit behind because I was away for a bit, but now I'm back. So I'm going to try to catch up. And then Max says, he gives the name of a lawyer is handling my negligent security lawsuit here in Texas after a shooting from a bar's negligence. Is he a good lawyer? That's more like a private thing. I don't want to talk, about specific lawyers on the channel. But if you text me and you need me to do a consultation with you, part of the consultation, which I did for somebody like today, I could look up a lawyer, and then give you their verdicts and settlements. So, that's basically, I could do that. And then and by the way, to text me, it's just 347-566-9595. And then Burns says, do you know how often do cases normally go to trial in Florida? Oh, do you mean like how long it takes to go to trial? Or I'm not sure what the question is, because how often? I mean, each case only goes to trial usually once, but you mean like, I'm not sure. Oh, you mean like how often, whether they settle or go to trial? I mean, I would say it's probably the same as everywhere. Most cases settle, but some do go to trial. And then Devin says, would a demand letter that is asking for $460,000 for a TBI with chiropractic visits that lasted 7 months, physical therapy that was needed for loss of balance, and primary doctor all collaborate? All injuries are directly or acutely aggravated. Thanks in advance. Trucking accident, 100% at fault for failing to yield to stop sign with 750 insurance, and I'm 72. I mean, yeah, it should. Why would they demand only 460 though? If they only have 750, what I would do is say, look, pay me 750. You have 30 days. If you don't, that's totally fine. But guess what? It's going to be 2 million. So give them like a clear deadline. Like, for example, today's September 25th, right? So say October 25th, 2025, right, at 5 p.m. That's a Saturday. So make it October 27th, a Monday, right? At 5 p.m. That's what you have. October 27th at 5 p.m. Okay. At 5:01 p.m. on October 27th, it's not going to be 750 anymore. It's going to be 2 million. And I'm going to go to trial and I'm going to show you, and then show them in the letter. Like, I write these letters, they're like 20-page letters. And I go through like the diagnosis of the TBI, the pain and suffering, the future medical expenses, all the damages categories that you qualify for. Now, if you're 72, then say, these are my golden years, right? I'm not going to live forever. People live to be like 83. So if I have like 10 years left, these are my golden years. I want to enjoy these years. I want to have a nice retirement. I want to enjoy with my family, my grandchildren, whatever. And you took that away from me. Does that have value? Are you able to just take someone's last years of their life? There's nothing else after that, right? You took all that away, away everything that I have, and you're telling me doesn't have value. So I would send a letter like that and really go through like if you have any, future medical costs, any, all the damages, but I would focus mostly on the pain and suffering, past and future, and then have them pay you the 750. Or look, if they pay you, I don't know, 700 or 690, it's up to you and your lawyer, you could take it. But by asking for 460, you're inviting them to then give you a third of that, right? Because that's what they do. If you're demanding like 460 and they're going to say, well, why is this guy only demanding 460? If it's a real TBI, he must not really believe in his own case. Oh, let's give him a third of 460, right? Which is like what? Like a 170 or something, or 150 or whatever it is. I'm not good with math, but you know what I mean? That's not good. And then they're going to start there, and then it's going to be hard for you to go back up. So I wouldn't do that. I would just, if you really believe in your case, and if your lawyer is a trial lawyer and believes in the case, just say 750. You have until October 27th. You have, 30 days. Here's all the evidence. Here's my medical records, whatever you want, like, authorizations. You have all the doctors, And then if they don't pay you, just say, okay, I'm going to go to court. But guess what? Why do I have to ask for the 750 in court? I don't. I'm going to ask for 2 million. And if the jury agrees with me and gives me, for example, 1,500,000, well, who's going to pay it? This poor little trucking company, all they have is 750. So am I going to take their truck? Am I going to take the company? Or are you, as an insurance company, going to defend your policyholder? Because guess what? You have a duty of good faith and fair dealing to the trucking company that's paying your premiums. That's your client, right? That's your policyholder, you're insured. You have a duty to protect them. You can't say, oh, I'm, big insurance company, screw my policyholder. I'll take their premiums all day long. But when it comes time to defend them, if they get sued, I'm just going to leave them out to dry and let them get hit for 2 million or 1.5 million. They can't do that. You see what I'm saying? It's illegal for them to do that. So expose that, put the pressure on them, put them in a corner, and then make them pay. And then they're going to be like, oh my God, what are we going to do? Are we going to pay the 750 now? Or are we going to risk getting hit for like 1.5 or over 1 million? And then, and then depending on which state you're in, that opens them up to bad faith law. And it might be that the policy is open. And then you could get the insurance company to pay you the entire jury verdict if it's higher than 750. So that's what I would do. But it really depends. But yeah, I mean, I definitely think 460. I mean, I think it's too low. I think it's way too low. Okay, and then her asks, hi Arkady, what example of proof is needed to convince a judge to allow a jury to hear a punitive damages claim in a state like New York? Yeah, so I mean, punitive damages, it's really has to be in New York. It's hard. There's a very difficult standard. I don't know exactly. I'd have to research it. I don't really do too many punitive damages cases, but I think I've done a few videos about it where they talk about the standard, and then they've also said like what the standard is, and then they've also said what qualifies and what doesn't. And it has to be something almost like evil, something like malicious, where they know that whatever their conduct is, it's going to hurt a lot of people and they don't care and they let you do it anyway. For example, like a trucking company, right? If a trucking company is like having a party, let's say a Christmas party or whatever, and everybody's drunk, and then they get a call and somebody says, well, I need a load across town in an hour, and then everybody's just drank a bottle of vodka. You only have like 1 or 2 guys, and you say, you know what? I don't care that you drank a bottle of vodka. Get in that truck and drive an hour and deliver that because I want to make money. And then he kills somebody, right? That would be, maybe you can get punitives for that. But other cases, it's very difficult. It's very difficult because punitives, remember, they're not covered by insurance. So whatever the insurance policy is, it's not going to cover punitives usually. So punitives are almost like you're suing the company and you're asking the company to pay out of their profits because they put profits over safety, right? They wanted to make so much money that they said, we don't care. We're going to hurt people, but let's hurt them anyway. Like in that McDonald's case, the famous one with the coffee, they made fun of it. They said, oh, this lady made $3 million for spilling hot coffee on herself. But the reality of it was the reason that they gave $3 million was because back then, and this was an old case from like the 80s, back then, that was how much McDonald's made in a day. So they gave 1 day's profits. And the reason they gave it was because McDonald's knew that the coffee was coming out so hot that it was burning people, like really burning people badly. But they decided not to change the boilers because it was more expensive to change those huge big boilers that was housing, I guess, the coffee in all the McDonald's, right, all over the country. It was more expensive to do that than to just pay people that got burned. And it was in the emails, like they did this analysis. They hired experts. The experts were saying, yeah, this is the problem. You could fix it. And they said, we don't care because let's just pay the people that we burn. It's much cheaper than fixing this. And they knew all that. And that came out in trials. And the jury got mad and said, that's punitive, right? So stuff like that. But I don't think, it is still hard. If it's just negligence, it's not punitive. It has to be like real evil kind of conduct. And then let me see if I missed any question. Let me go back up. David says, what would defendant not schedule depositions after 2 years? I mean, depositions, they're not scheduled by the defendant. It's court ordered. So if they don't do the deposition, you could argue it's waived. But the deposition, it should go forward, fairly soon. And then Stacy says, Florida truck injured me. Defense stipulated to being at fault. Inexperienced, rushed attorneys didn't do a good job. Wasn't allowed to enter Important evidence, jury rushed, I lost. Any help? Well, I mean, you'd have to speak to some Florida lawyers. If you already lost, it's tough. You'd have to do an appeal and find a mistake that the judge made, maybe to do another trial, but it's not easy. A lot of the times, unfortunately, when you lose with a jury, they just let the jury verdict stand. And then Short Guy says, it's been about 2 weeks and my attorney hasn't given me a phone call or update. Is it normal to take about 30 days to prepare and file the complaint? Yeah. I mean, to file a complaint, yeah, about maybe even less. I mean, a complaint now with all the software, I mean, like I was talking earlier about AI, you probably could file complaints too. You could draft complaints yourself, but now a lot of the software, if people use the case management software, they have, you just press a button and the complaint comes out. It takes like 5 minutes, so it shouldn't take too long. And then Max says, I wish you practiced in Texas. I would hire you in a heartbeat. Oh, thank you so much. Actually, I went to law school in Texas, so I am admitted there. I took the bar and I passed the bar there. So I do have a license there. I just don't practice there because I live here in New York. But I know a lot of excellent Texas lawyers. So you could always text me. And what I could do is have them help you. And then if the case goes to trial, I could even come down and do the trial with them. If you wanted that, I could do that. It's 347-566-9595. And then Mark says, injured friend got defense verdict, now need to keep last of her money for treatment, but Dent wants it all, put her on the street. Any type of attorney to help her, any advice? So you're saying, so she got a defense verdict, so she lost her case? Oh, I see, keep her money for treatment, but you're saying the defense wants it? But why would the defense want money if they already won the case? I'm not really following that, but yeah, I mean, like, just text me. I'm happy to, try to help you or text you back. And then, what are the chances if the other person is 99.9% at fault and we file the suit, would they most likely settle early on the lawsuit or would they fight? Well, I mean, it's hard to say it's hard to say what will happen just based on those facts. Now, if they're 100% or almost 100% at fault, they could still fight you on other things, right? They could accept liability and say, yes, we were negligent. Like, for example, we hit you in the rear, but guess what? We just tapped you. So whatever we did, even though we were negligent, right? We didn't follow reasonable care. We shouldn't have tapped you in the back, but guess what? It didn't cause anything. Whatever you're claiming, you've already had before. You had it a week before we hit you. You had it a month before we hit you. We had it a year before we hit you because you're, 42 years old and you have the spine of a 42-year-old. So all of these normal changes like bulges and degenerative disc disease, this is all just from living your life. We didn't cause this. So they could defend on that, right? So there's other defenses that they could do, even though, they accept, liability or fault. But to answer your question, I mean, of course, it's better for them to have fault than not to have fault, right? Because if they're not at fault, then they're not going to pay at all. They're going to say, well, why are you even suing us? So, I mean, of course, it is more likely that they will settle if they're at fault. But I'm just saying they could still defend even being at fault. And then Stacy says, really wanted to know if I can keep guilty defense that won from making me destitute. Yeah, I'm not really sure what that means, but like the defense shouldn't be able to make you. You're saying if the defense won, like is that the same question that Mark asked? Like if the defense won, it just means that you lost the trial. So you're suing them for money, like for your personal injury. You're trying to get, let's say, $1 million. They say that, you know what, you don't get it. You lose for whatever reason. You get zero. But then how does the defense sue you for money? You're saying that they want some kind of legal fees or they're trying to get costs or something like that. But then maybe your lawyer could work that out with them. I haven't really heard of people having to pay much after a trial. I think you're entitled to, and it's the Seventh Amendment, right? You're entitled to go to trial, take a jury verdict. Sometimes people lose cases, but you shouldn't really become destitute over it. And then Stomper says, hello, hi. And Short Guy says, USAA has the 300K policy, but my case is worth around 150 and they offered 99 before filing. Keep in mind, surgery was recommended for ADR neck, but I didn't proceed with it. 99K is good, but my med is 75K. Oh, I see. Right. So you just want to get more. Yeah. So yeah, definitely. That sounds like it should settle. If they're already offering you 100 and you're saying you only want 150. But again, like, go for the 300. You know, why is everybody trying to, you got to remember, look, the insurance companies just want like to save their money, right? They want to pay you as little as possible. So if you ask for a little, they're going to give you, like, if you ask for 150, they're going to give you 50. Well, they already gave you 100, but you know what I'm saying? But if you tell them, hey, I think it's worth 150, they can start you off at 50 because they know that they'll never have to pay you more than 150, right? So why start at 150? What you're basically doing is giving them a gift of $150,000. Now, I don't know about you, but I don't like to give people gifts of $150,000. That's a lot of money. Well, and why? Like, for what? Just ask for the full 300. Just tell them, you know, I don't even like the word ask or demand. Just tell them, hey, civil justice in this case is 300,000 or whatever your policy limits are. And like, you have 30 days. Here's all the proof, like I was saying earlier. And if you don't pay it, that's fine. But then guess what? It's not going to be 300 anymore. It's going to be like 750 or it's going to be $1 million. Like, you know, scare them, make them pay. That's how I would do it. Why, you know, why limit yourself? And then Willie says, good evening, Arkady. Hope all is well. Yes. Hi, how are you? Willie's a really nice guy. We talked, I remember one time we did a consultation. And then Max says, have you ever sued Uber? Yeah, we have. We have cases against Uber, of course. And then Stomper says, have you received any $1 million verdicts in Queens, New York? If so, when was the last time you handled that case and how well into the millions was the verdict? Yeah, in Queens, I don't remember any verdicts. I haven't really done too many trials. Lately, the trials I've been doing have been in like Brooklyn or the Bronx. But I did have a Queens case that I settled for, I think it was 2.8 million. It was a construction case. So a guy was like doing construction and something fell on his back and he ended up having a back surgery. And we settled it for 2,800,000. That was Queens. And I've had other cases in Queens that went for like significant amounts. Queens is fine. I mean, I've heard of some nice verdicts in Queens. The only thing with Queens is that, you know, it's very mixed. You get a lot of different, just like, you know, there's different communities. There's like Asian community, Chinese, right? Like Chinatown, like Flushing. Then you have like the Spanish community, Jackson Heights. Then you have some other community, maybe like Indian, also maybe like somewhere near Jackson. Even in the same, like Jackson Heights, you could have Spanish, Indian, something else, something else. So you have to be like careful when you pick a jury. You have to really, I mean, not about the where they're from, right? It doesn't really matter. People could be fair and be from any, you know, ethnicity, but it's a really diverse melting pot. So what you have to do is you have to tell them the issues in your case and like your danger points, right? With your fears, and make sure that they can allow for a verdict. Because if they can't, they should just tell you, and then you get them off the jury. So, for example, if you have a case with a serious injury like a spine fusion, you could say, like, you know, the evidence, you know, my belief is that the evidence and the law, when you match it up, it's going to justify a verdict of $5 million because this is like a life-changing forever injury. And, you know, how many of you are okay with something like that? Or how many people think like, no matter what, I just can't allow for that? And if people start saying, no, I can't allow for that, I can't do more than like 10,000, you know, you get those people off. And it gets a little bit more involved, but that's what I would recommend. But yeah, Queens is not really a bad venue. It's just like you have to know how to pick the right jury if you're going to go to trial in terms of a verdict. But if you settle, you know, obviously that's a settlement. That's like a more of a like a contract, right? And like a shake hands deal, but you sign and then you get the money that you settle for, which is, you know, in many ways, you know, preferable. Because if you can get a nice verdict, right, you can go to Queens and get a $20 million verdict, but guess what? They're just not going to pay you the $20 million. They're just going to appeal. Then the appeal is going to take 5 years. And then the appellate division is going to say that's too high, take like 2 million. Or if you don't like it, then do another trial. And it just never ends, right? People want closure. People want their money, their actual money, and just closure. And then JP says, what defines bad faith law? If the insurance company refuses the policy limits, does it automatically open the policy? Does bad faith happen a lot? Yeah, well, I mean, it's a little bit more complicated than that. There's like 10 different things that you have to do. That's why I was saying these letters sometimes are like 20-page letters. But yeah, it depends on if the state has bad faith law, because some states have it and some states like New York don't. So it just depends on where you are. And then DND says, so it happened in Miami and the defense already denied everything, and even denied it happened in Miami. We are already in the discovery process. They were supposed to give us discovery September 8th, but asked for the 30-day extension. They just haven't asked for anything. So I thought that was a good sign. Yeah, I mean, they do, you know, sometimes don't give you discovery. That's why you have to really follow up and like really try to get it, because they just don't give it to you. Like they hide things, they ask for extensions. Give me 1 minute. I'm gonna just go have somebody at the downstairs, I think. So I'll just be back in 1 minute. I apologize. But yeah, we'll finish up with all the questions in a second. Okay. Okay. Be right back. Oh, okay. We're back. Sorry about that. Just had somebody at the door. Let me see. Okay, so we did the D&D question, right, about the 30 days. Yeah, we did that one, right? 30 days extension. And they haven't, but 30-day extension for what? For to answer the lawsuit, or oh no, they answered, they denied, maybe for discovery. But you said they haven't asked you for anything, but they will ask you for, discovery. I mean, I've never heard of a defense firm not asking for discovery, and then they wouldn't know anything that would be impossible to defend. So they're going to ask you for stuff. Okay, and then George says, do you know some kind of lawyer from Houston? No, I don't think I know that lawyer, but I could, like I said, I could do a search for you and tell you, like, if you give me any lawyer, like, just text me, or maybe we could do a consult call. We could discuss it, and then I could search like the first name and the last name and their city, and then I could tell you like what verdicts they've gotten, what settlements they've won in the past, and we could, I could do that research for you. I have those databases, so I'm happy to do that. And then Enough says, I won my summary judgment. How much more time do you think till settlement or trial? Okay, that's good. Congratulations. Yeah, summary judgment is good to win because then you get judgment as a matter of law. I wouldn't be able to tell you, depending on where you are in the case, right? Because you can file a summary judgment in the beginning. You could file a summary judgment after depositions are over. So it just depends on where you are in the case. But it definitely increases the value because now they have to pay 8% interest on top of any judgment. So it increases the value of the case. It also makes it more likely that you're going to win and makes it more likely that they will settle. But I couldn't tell you exactly like when, but it sounds like it should be definitely a motivating factor. And then Jonathan says, hey, Mr. Frekhtman, I have a question. Once any case finishes their deposition, will the media find out? I mean, usually not. The media usually doesn't know about depositions because that's more of like just a private thing, unless it's like some kind of high profile case where they're really following it. But you could, but so usually not. And then Money Dog says, does a jury know if you are awarded a certain amount of money, how it gets broken down with medical bills, attorney bills, and extra costs in the lawsuit? No, the jury doesn't know about that. Well, they do know about bills, right? So you basically tell the jury, and during the trial, you present the evidence. So you have your, like, for example, you have your future medical costs, right? So that's one element. Then you have your past pain and suffering, future pain and suffering, or whatever the categories. You might have lost wages. So those all get awarded by the jury, right? And the more categories you have, the more, but they don't know about attorney's fees because that's something that's separate, right? So whatever they say, they give you $1 million, then the attorney's going to take 300,000, give you 700,000, but the jury doesn't hear about that. That's more like behind the scenes kind of thing. And then Short Guy says, you mentioned about AI. My attorney should have filed by now. 2 weeks. He seemed like a good litigator. He just takes his time. I feel like he's going to take his time and call me in 2 more weeks. Yeah, it might be. I mean, it's hard to say. Like they could be, people get delayed not just because they're taking their time, but because they might have other things. Like, sometimes you get urgent things like a motion is due. So if you don't do the motion, the case will get dismissed. So you have to do the motion. And if he's like short staffed or he doesn't have that many other people to help, he might have to do that motion because it's due final. And then meanwhile, your lawsuit is not really final. He just has to prepare a complaint. So he could do that next week, right? So he might put it on the back burner to do this. So it just depends on, just an example, but it depends because, the law, you always have like things and then sometimes things pop up and you don't even know about something. And then something pops up, becomes an emergency. So it's kind of like you try to keep everything moving. And then Max says, what happens if an insurance company tells you you did not have UIM coverage, but after further research, you find out you did? Progressive is a Progressive insurance are snakes. Can I hire you for a case if I already have an attorney for another case? Well, if you have an attorney, you could switch attorneys, but you can't really have 2 attorneys for the same case. And in terms of if they tell you you do not have the UIM, but you do, you just have to, I guess, call the adjuster and show them, hey, you were wrong. I have it. Here's the proof. And then have an attorney file the UIM arbitration, and then you should be able to win that. And then Stomper says, how would a great case with clear liability, great policy limits, and multiple injuries, as well as a heartfelt human story, even end up in a Queen's Court for trial, even if one had a trial attorney? Well, I'm not sure what you're asking. Like, what do you mean a great case with clear liability? I mean, yeah, if it has clear liability and if there are large policy limits and you have a lot of injuries, then and you have a strong human story, then they should settle with you. But if they're not offering you enough, or if the amount for whatever reason isn't sufficient, then you might have to go to trial. I mean, because these are all like really general things, right? Like you're saying it's a great case, but maybe somebody else thinks it's not a great case, or they have a defense to it. So we'd have to look at the file. We'd have to look at the nitty gritty. Like, what is it that, like, what happened, right? That's always a good place to start. Like, what are the facts? What are the injuries? When did it happen? What are the defenses? We'd have to like examine the case like in detail. I mean, anybody could say, I have a great case. Why don't they just pay me $100 million, right? It's just very general. I can't really comment on that. Okay, Max James says, this guy is gold, an attorney who actually talks to you. Oh, thank you so much. I appreciate that. And Stomper says, I understand plaintiffs mess up their cases during pretrial testimony. But besides that, I guess my question is, are there really good defense trial firms who strategically fight hard and take you to court? Yeah, I mean, of course, there are good lawyers on the defense. Yeah, sure, there are a lot of good lawyers. I mean, like, there's good lawyers on both sides. There are good lawyers on the plaintiff side. There are good lawyers on the defense side. And the defense side, what I've seen is like lawyers that handle medical malpractice cases. They're really good because they're very complicated cases. You might be dealing with thousands of pages of medical records, also difficult standards. You got to talk about deviations from good and accepted practice. So sometimes those lawyers will then do regular cases like car accident, but they're really good lawyers. So it's harder to fight with those lawyers than it is to fight with like some in-house counsel for like Allstate or like, the yellow cabs, like those are easier, right? So it really depends, but sure. And there are good trial lawyers for the defense. Sometimes they make really good arguments. Sometimes they, like anything, right? Like it's hard to, like, I've watched some trials even on CVN, the Courtroom View Network. And sometimes they have a trial with this attorney who's like a really good plaintiff's attorney, and he gets like, a verdict of like 50 million or a verdict of 30 million, or he's like I think he even had verdicts of like 100 million. He's a really good, one of the best in the country. But then sometimes they put lawyers up against him who are like the best defense guys. And so you could watch both of them and you could see like how they, both make really good points. So like in the direct exam, you're thinking, oh, wow, this is really good for the plaintiff. But then in the cross, you're thinking, oh, wow, but he's making good points for the defense. Then the redirect, now it's coming back to the plaintiff. It's like, imagine like two teams playing, right? One is like a good, like any sport, right? Imagine like football or basketball, like two teams. And then it's like, coming down to the wire and it's like 98 to 100 and who's going to win, or it's 100 and 100 and who's going to win? Whoever shoots the last basket is going to win, right? So it's like that. They're both good. Yeah, and it's totally normal. And then Ben says, are juries more biased toward awarding less for motorcycle injuries, or has that not really been a problem? Well, I mean, you got to ask them in jury selection. So some people are, right? It depends on the person. Some people don't like bicyclists, let's say, because maybe they live in New York City and they walk a lot and bicyclists come at them, or they drive and they feel like bicyclists are like taking up the road and they don't like bicyclists. So they have this bias towards bicyclists. Well, guess what? You don't want those people on your jury if you're representing, as a lawyer, if I'm representing an injured bicyclist, I don't want those people on my jury because they're going to vote against me. So you got to ask them in jury selection. And the same thing with motorcycles, right? Some people are okay with motorcycles. They just think motorcycles are another vehicle, just like, cars. Or some people might even be pro motorcycle because they ride, or their friends ride, or their family members ride motorcycles. So it just depends. But in general, I mean, I think I have seen some people talk about bias with bicyclists. Motorcyclists, I mean, a little bit. I think some people might be a little biased in the sense that if you're riding a motorcycle, you're choosing to ride, let's say, open, right? Obviously, there's no cage like in a car, so you're unprotected. So kind of like you're assuming the risk. So some people might think that. So yeah, it would be like you'd have to prepare like a voir dire, a jury selection outline, and really get into the issues and try to be like vulnerable and go to the core of it, go to the heart of it, and find some of the universals that everybody would agree on and see what people say. And McAdoo says, I got hurt at work and filed for workers' comp in New York. Okay, yeah, that's proper. Yeah, if you got hurt at work, it should be workers' comp. You could also have a third party action that would be against a third party, not your employer. But that's, you'd have to know how it happened, and you might have that. And then Jonathan says, a high profile case against NYPD, catastrophic injuries, corruption. Yeah, no, I'm sorry to hear that. That happens. Yeah, of course. And then Kevin says, I have a deposition for underinsured motorist this upcoming month. Any advice? The other party paid out medical bills, 32,000. Yeah, I mean, deposition, it's always the same. I would just really, you know, listen to the question, try to answer what they're asking you. Don't volunteer information, don't give extraneous stuff, just answer what they're asking you. Yeah, it should be fine. Just you could watch my video. I have a video called Super Depositions where I go through. It's not for a UM case. It's more like for a regular PI case, but it's probably pretty similar. They're going to ask you about how the incident happened. They're going to ask you about your injuries, your treatment. So it's very similar. Short guy says, I really appreciate your answering these. You're really good at what you do and deserve a good review. Oh, thank you so much. I really appreciate that. And then Kevin says, this doesn't pertain to PI, but in criminal cases, we're told to be honest to our attorney. If someone actually committed a crime, do you let your attorney know? I always wanted to know if your attorney actually believes you or defends you, even if they know you're lying. Well, I mean, the attorney just has to defend you to the best of his or her ability. It's hard to say. I mean, if you tell the attorney, I mean, usually I don't think that you tell the attorney, hey, I did it, but just defend me anyway, right? Because then the attorney might not be able to defend you if they already know that you did it, right? So, but it's hard to say. But I don't really do that much criminal. I used to do a little criminal back in the day, like when I first started back in this was like the year 2000 or something, like a long time ago, or 1999 when I first started. I did a little criminal. I did some criminal defense, mostly, defense. Like I did some small cases like marijuana possession, DWI. We even did some big cases. We did one like assault case where a guy got into like a fight with this old man, and the old man fractured like his orbital bone and his eye, and they were trying to give my client 8 years, and the client wanted to take it, but I told him, no, don't take it. Let's just go to trial. And then we ended up getting him like no jail time, just a small misdemeanor. So it was a good thing that he listened to me, because he would have done 8 years otherwise. And then we had a guy accused of rape who was like looking at 25 years, but we got him a not guilty verdict. So yeah, criminal cases are different, but in terms of your question, yeah, it's a good question. It's really, I'm not sure if that's more of like an ethical thing, but I don't think most people that are accused of a crime are just going to tell their attorney, I did do it. Because, the other thing is, even if the attorney is able to represent you despite you telling him that, the problem is now the attorney's going to know, well, this guy did it, right? What am I supposed to, how am I going to defend him and argue that he didn't do it? Everything's, it's like, it's hard to do, right? Because now everything's a lie, right? All my arguments, all my prep, everything's like basically a lie. So it's like, it's hard to do. So, and then King says, hey, Arkady, are you familiar with the law firm? Oh, he gives the name of a lawyer. Yeah, actually, I am familiar with them, but I can't. Yeah, I could do a verdict search. Just text me. We'll do a consult call first, and I could do a verdict search. I'll send you results. And Jonathan says that the body cam footage shows them lying. Okay. Yeah, that makes sense. Okay. Oh, just news. Okay, and then short guy car reviews says, I was in a wreck before, no treatment at hospital. Will this ruin the case I have going now? How can I defend this type of situation if asked about a previous accident? Do I say I was not injured? Well, no, you want to be honest, because they're going to find out about it anyway. And the idea is, if you had something before, you healed from that, or they take you as they find you. So you could have something before, but now whatever you had before was made worse by this crash, the one you're suing for. So it's just, I've talked about this a lot before. I don't know if you watch those videos, but basically it's like, if you didn't have anything before, you'd be like a 10, let's say, right? And then this crash brought you to a 7. So you're still okay. You're still a 7. But if you were already a 5, right, or because you had a prior injury, well, now this crash brings you to like a 2. So it's like they took everything from you. You have less to give, right? This is like kind of pushed you over the edge, right? And we don't say people that are already frail or already hurt or already vulnerable should get less, right? You just kind of take your plaintiff as you find him or her. Some people might be like bodybuilders, super in good shape. They get hit, nothing happens. Other people might be like octogenarians, 87, walking frailly already. They get hit. The same exact thing that happened to the bodybuilder, but hits the 87-year-old. He falls over. He has like a brain bleed. He might need brain surgery. He'll be in the hospital for months, rehab for months, if not years. Might die, right? So you can't say, well, I'm not going to pay because I hit the one guy and not the other. It's just whatever it is, it is. So I wouldn't really worry about that as long as your lawyer knows how to handle those cases. And then Short Guy says, serious question. How can I hide or avoid being followed or caught by the private investigator if they have one? No, I mean, just don't do anything that you said you couldn't do. Like, for example, if you testified that you can't, lift a certain, shopping bags, and don't go and lift shopping bags that you said you can't. Just be honest, and don't go out there and do anything crazy. Like, I had a case, I settled it during trial for 3.5 million, and they surveilled the guy and they had him doing stuff. But the only thing they had him doing was like driving his car where he said he could drive, getting out of his car, going to the back, pressing the button or whatever on the remote, the hatch opens, and then he takes a paper for some reason and looks at the paper, and then he goes back and to the drivers. I'm like, okay, who cares? Like, that's not, so I prepped him. So that's all they had on him. So it didn't really hurt us. But yeah, of course, I had another case where a lady said that she can't lift anything, and they had her like in Costco, and she's picking up those 5-gallon water bottles and she's putting them in the back of her station wagon. And, I settled that one too, but I got a lot less money because she said she couldn't do it, and she's doing it, and they have her on video. That's not good. So just don't do anything that you say you can't do. Just be true to your word. And then DND says also about the fall through the floor. We found out the CEO had a quote to replace the floor 2 weeks prior to my falling. And once I fell, they had an emergency meeting and replaced the floor. Okay, so that's good. If they were supposed to do it before and they didn't, that's negligence. So I would definitely, it could increase the value. That really goes to more like to liability, but yeah, definitely helps. And then Stomper says, instead of telling an untruth at a personal injury pretrial testimony, is it okay to admit something that will hurt your case? Because when the trial attorney will focus on the strength of my case, do we score credibility points by telling something that we know is bad and admitting it to the defense? Yeah, I think so. I always tell people to tell the truth, right? Because if you hide something and then they bring it up, well, then they're going to be like, look, you're a liar. And then if you lie about one thing, well, you could be lying about everything. It's called falsus in uno, false about one thing, false about everything. Now the whole case could just crumble like a house of cards. So yeah, better to tell the truth depending on what it is and just neutralize it. Or if it's a bad fact, like for example, if you've had an arrest or a conviction and and the judge says, look, I'm not going to exclude it in a motion in limine, it's going to come into evidence. But it was something like a long time ago. Maybe now you're like 50 and it happened when you were 23, just, drunk driving or whatever. And you had a conviction and you served some time. Just admit it. Be like, yeah, I paid for that mistake. I served my time. I did my whatever program, or I served my jail time, and I'm a different person now. I learned my lesson. Should that mean that I get less now, like 30 years later, because I had that mistake? Depending on what it is, because some of these questions, they're very, very general, so it's kind of hard for me to answer. But depending on what it is specifically, I could tell you. You just text me. I could do a consult. 347-566-9595. And Miguel says, after 4 years and 2 fusions and 3 other surgeries, which follows after the IME? Yeah, no, that's serious. Those surgeries are very serious. So that should be a big case. Okay, I guess that's good. We covered all the questions. We've been at it for almost an hour. Thank you, everyone. Please like and subscribe to our channel. Let us know what questions you have. If we gave you good advice, you could also click in the description and leave us a review. That's always helpful, like on Google, because that helps people find us here in New York, like clients who are looking for an attorney. And our goal is helping serious injury victims and families. And, that's what it's all about. Okay, everyone, please like and subscribe to our channel. Let us know what videos you want to see in the future, and we'll shoot some new ones for you, and all the very best. Okay, have a great night, everyone. Bye-bye.